Thank you. Good morning. This is an evidentiary hearing in case number 25-3111-NM, the application of Canaan 102 Solar LLC for a certificate of public good for a 500 kilowatt solar net metering electric power system in Canaan, Vermont. My name is Aaron Kasicki. I'm the staff attorney with the Vermont Public Utility Commission, and I've been appointed to serve as a hearing officer in this case. Today's hearing is being held remotely on the Microsoft Teams meeting platform. The hearing is being video recorded and audio recorded, and an unofficial transcript is being generated by Teams. A copy of the hearing recording or the transcript can be obtained by contacting the clerk of the commission. I'll start by taking notice of appearance in the order that people appear on my screen. If a party or participant intends to report today's conference separately via video or audio, please indicate this when you provide your name. Start with the Department of Public Service.
Hi, Michael Swain here, representing the Department of Public Service.
Morning. Next is Ms. Boschman.
Good morning. Carol Boschman, pro se, representing the abutter.
Next is Canaan 102 Solar.
Leslie Cadwell, legal counselors and advocates for Canaan 102 Solar LLC. And can I just ask a clarification? Ms. Boschman said that she was representing an abutter. Is my understanding that Ms. Boschman is representing herself as an abutter? Yes. Okay.
Do you have anyone else who wants to identify themselves? We had a brief discussion. Prior to the hearing, and we talked about some evidentiary issues. Again, the parties have filed a list of evidence to be offered and stipulated to their admission that they filed prior to the hearing. I appreciate that very much. Just for the record, I'm going to quickly go through that evidence that's being stipulated to, and then we also have one piece of evidence that there's an objection to, and review of that. So the following testimony and pre-filed exhibits are stipulated to by the parties. It is the pre-filed testimony of Jeff Martin. It's the corrected version as of June 8th, 2026. Supplemental pre-filed testimony of Mr. Martin exhibits petitioner GM 1 through 5 and 7 through 8. There's also the pre-filed testimony of Marcus Vasquez and exhibits petitioner MS1 and MS2. MS2 is a corrected version as of June 8th, 2026, as well as petitioner MS3. Also, the pre-filed testimony of Tori Barton exhibits petitioner DB1 and 2. There's also the pre-filed testimony of Carol Boschman. The supplemental pre-filed testimony of Carol Boschman exhibits 1 through 4 and exhibit 6. I'll also note that Ms. Boschman's pre-filed testimony, I issued an order earlier this week that outlined that a portion of Ms. Boschman's testimony was to be struck. That's on page 12, line 181, that makes a reference to property values. Ms. Boschman has not filed an updated or revised copy of that testimony. My understanding is that it may be forthcoming after the hearing before a briefing. I just wanted to make that note for the record. We have one exhibit that seems to have an objection right now, which is exhibit PET GM6, which is a letter of interest from Rural Edge that is to supersede a letter that had been filed with the petition back in December. This new letter was filed on June 2nd, 2006. Ms. Boschman, if you want to outline the objection. Sorry, you're on mute.
Sorry about that. So we had a conversation, Attorney Caldwell and I, just before this hearing a couple of days ago when I saw this posting come through. In the conversation, it appears that my question on why is it happening now, and the continuation of that conversation was interpreted to be my approving, supporting having that letter submitted. And I have concerns around the timing of an entirely different letter in substitution to something that was submitted back in December, as opposed to what I read as a revision. And maybe it's my not understanding the legal process, that it is interchangeable because it's the same kind of document. So that was the question and the objection that I was presenting today to have for consideration as to whether or not it should be retained in this hearing at this time.
Ms. Caldwell, do you have a response? I'm
You're on
sorry, you're
mute.
on mute.
There we go. Thank you. Ms. Boschman's not prejudiced by the substitution of the Roll Edge letter for Down Street. It's a single page. She has the opportunity. She has just as much opportunity to inquire about that letter from Roll Edge as she did about the Down Street. And I would ask that the hearing officer waive any strict adherence to the to any timing. Because there is no prejudice to Ms. Boschman. She did not request or issue any discovery related to the Down Street letter. She did not file any objection to the Down Street letter. And I'd like to have substance overrule procedure here for something that she does have an opportunity to inquire. And she's had time to prepare questions about that letter since it was filed. So I'd ask that the commission accept it and overrule the objection.
Ms. Bushman, a quick question. I assume based on what Ms. Caldwell just said, is it, I take it that you didn't have any objections to the initial Down Street letter, the one that was filed in December, is that right?
For lack of legal process awareness, I had no reaction at that time.
Okay.
Correct.
Okay. And so I get the secondary question is there anything materially different that you can point to in this newer letter that was filed on the second that is different from the one before that you specifically object to?
I think the difference is in the first letter was a letter of interest, but no binding contract or agreement that they would engage. This letter does. Not a contract, but does express interest and readiness to have low-income residents be able to address and be able to take advantage of this opportunity as they present it.
May I respond?
Yes.
That's just not true. The letters are the same. They express interest, and they both expressly do not say that it's a binding commitment. These are simply letters of interest.
Thanks to the both of you. Based on the objection and the response, I'm going to admit the revised PETGM 6 that was filed on June 2nd. I understand your concern, Ms. Boschman, but in terms of the substance of the letter, it seems materially the same as far as I can read the two. And considering that there was no objection to the first one, I'm going to overrule the objection in a bit.
I understand.
That is the evidence. So thank you. So thank you for stipulating to the bulk of the evidence. I appreciate that. The next order of business is to call the first witness, and my understanding is Mr. Martin will be the first witness. Case.
Should I call him?
Please do.
Okay. I called Jeff Martin for Canaan 102 Solar.
Very quickly, Mr. Martin, before we start, I have to put you under oath. Do you swear or affirm under penalty or perjury that the testimony you are about to give will be the truth, the whole truth, and nothing but?
I do.
Thank you. Ms. Boschman.
Yes.
Do you have any cross-examination questions for Mr. Newman?
Oh, I'm sorry. So here I go with my questions. This is my turn to go through this process. Apologies.
Perfect. And
Pro
I will say
se.
this very quick. I will say this very quickly. Take your time. We have time, so just don't feel rushed.
Thank you. And bear with me as this adventure is not my normal world. Higher education is. So I will do my
Understood.
best to go through the process in a respectful manner. So, Jeff, I really, if we're okay, just to have conversation. Are we allowed to do it that way? Aaron?
You can.
Yes? Okay, thank you. Or yes. Um, Jeff, conversation for me helps me feel a little bit more comfortable versus interrogation and all of that. So that's where I'm coming from. So I'm really interested to learn from you, really in general, to guide us through the rest of the conversations throughout this process. Can you talk to me about the process of engaging and moving forward with proposing this type of site location proposal? When does it begin? How do you locate the locations, engage with a landowner to begin the process?
Sure. In this particular case, the landowner, the Drews, approached Norwich Technologies with interest in hosting a solar array at their property. And so, in this case, they reached out to us. We do a review of the property, and if it looks favorable for solar, we'll proceed with putting together the application, the net metering application. In this case, we looked at different designs, and we settled on the one that's before the commission today for a variety of reasons. But yeah, that's generally, specifically in this case, it was the landowners that reached out to us.
In general, beyond the landowners, is that a common practice? It's generally the landowner reaches out to you versus you reaching out and finding other or other locations?
Yeah, it can go either way. We certainly get lots of inquiries from landowners that are interested in hosting solar.
And when you mentioned, you were talking about if it benefits or if it favors, for the solar company, you move forward in the process. What are the elements that contribute towards making that kind of a decision?
It has to be, there has to be access to three-phase power. There needs to be capacity with the interconnecting utility. And, generally speaking, it's preferable, particularly when in a net metering case where there's a rule limiting the amount of tree clearing that can occur. Generally favor sites that are open. Again, with access to three-phase power.
How long does that process of assessment take in general, right? In order to have, I'm trying to understand when you began this journey from the GRUs reaching out to you to when you submitted the actual advance notice document.
Yeah.
I want to just object here. I understand that Ms. Boschman may be interested in a process, but we're here about a specific project. And Mr. Martin's testimony doesn't talk about this. He talks about specifically to address the criteria. So I'm not really sure what, I'd like her to sort of to get to the relevant part of what's in his testimony and cross-examine him on his testimony, as opposed to sort of a global, global issue that doesn't really have any specific relevance to the issues in the case.
I'm trying.
Understood. Ms. Boschman, can you explain how this line of questioning is relevant to the project that we're reviewing right now?
Some of the testimony that I submitted was relation to different town plans and the timing elements of those time plans. And so I'm just trying to get an understanding of when this project began from Jeff's perspective to when it was actually submitted in correlation to the transition of one town plan to another.
Okay. And can you point to somewhere in Mr. Martin's testimony where that issue is, where that would be relevant to Mr. Martin's testimony?
I don't know that I can give you a specific statement here. I put together my questions as they were. So I don't have a specific line. Go ahead.
No, go ahead. So I'll allow this questioning for now. I think it may be foundational. But I want to be clear, is generally speaking, the questions that you're asking need to relate to Mr. Martin's testimony or the exhibits that he is offering, he is sponsoring.
Okay.
So I'll allow a little bit of this questioning because it does seem to be maybe a bit foundational. If we could pivot to looking at the specific project that we're here for.
Okay. Sure.
No, I'm sorry, Ms. Cadwell, I'm overruling objection.
No, thank you. And I don't want to necessarily cut her off. I just, I don't want to
Get
be
to
here
the
all
point.
day talking about generalizations.
Get to the
right?
point.
Yeah, exactly. Thank you. Thank you.
So Jeff, can you talk about the length of time in correlation to this project, right? From when you began, I think that was the question that I was asking you, when you began this adventure versus when you actually formally submitted your advance notice document.
I don't recall the specific date that I became involved with this particular project. But the 45-day notice, advance notice, was submitted on October 24th of 2025.
So do you know, well, I should ask, when did you jump into this project? That might help me better understand, because I think the project started before you jumped into this.
That there was a separate project that was started before I became involved. I think you're referring to a 3 megawatt project that was proposed in 2024, I believe. But that project I was not involved with. Again, I don't recall the exact time that I became involved in this project, the 500 kilowatt net metering project.
Okay. Bear with me. But it was still the same landowner and it was still the same property that was at play for the same type of project, just different size, right? From 24 to 25. Is that correct?
Correct. It was the same landowner, the same property. I would say that the type of project was very different, being a 3 megawatt project, 6 times the size of the project that's proposed today, and participating in a different program. A project of that size could not participate in that metering.
I think you're honing in that I didn't hear clearly. My next question was, how did we make it to same land, same owner to be a larger project to this smaller project that was submitted and we're discussing today?
I'm sorry, Carol, could you ask the question?
I'm trying to understand how we transitioned from 54 acres to 2 acres, but with the same landowner and the same property.
My understanding is it was a capacity constraint with Vermont Electric Co-op.
I see. Thank you. When you began the process with the town, what was the timing element for getting I recall, I think, meeting you this way first time when it was the town meeting to announce, and your testimony, I think, was talking about right around the same time, but just after you submitted the 45-day notice, correct?
I apologize. Could you please repeat that
The
question,
timing
Joe?
of when you met with us in the town and with all the, the selectmen's meeting to walk through the project was right after the 40-day notice, right?
The 45-day notice was submitted on October 24th. The first meeting that the project had with the town was with the Planning Commission on November 6th. And then the select board meeting was November 10th.
Okay. The November 6th was the zoning board, you said?
Correct, the Planning Commission.
And then November 10th was the town.
Yes. Was the select board. Yeah.
You're not a selectman, you're not a zoning board member, but I want to ask the question, and if that is reasonable time for a zoning board to vote or discuss, get minutes out on the zoning board, submit on a public site, and have enough notice to have the town aware of the event that is being proposed on the 10th. That's not even 5 days, and I'm pretty confident the selectmen meeting was on a Monday. Is that normally from your other projects, the window of time that happens from one communication to another?
So we're following the PUC requirement to hold preferred site meetings with the town, and those are the meetings that we have with the Planning Commission and the Select Board following the issuance of the 45-day notice. So that was the reason for the timing with the meetings with the town.
Oh, I understand, but I'm asking the question, in other organizations, in other projects such as this, is it normal, is it routine that the window of time for meeting with the zoning board and getting the vote in and meeting with the town, is that the normal time frame? 4 days, including weekend days, for that process to happen, to communicate to the community and have the community engaged in that process?
I'm going to object to this. Mr. Martin doesn't talk about this in his testimony, and I don't, as Carol's or Ms. Boschman's question, the premise of her question is that he's not a member of the select board or the planning commission. And so the question really, I'm not sure what the relevance of the question is or whether Mr. Martin is even qualified to answer it.
Do you have a response to this question?
My understanding from you, Leslie, was these were the only possible witnesses to have. So this might have been a question I would have asked the town selectmen or the zoning board, but I was not permitted to have them as witnesses to be part of this process.
Well, that's not true. You could have produced them as witnesses as part of your original case. I never told you you couldn't have other witnesses as part of your original case. What I did say was that the only witnesses that can testify at a hearing are those that have pre-filed testimony.
Okay.
I'm going to sustain the objection. It's unclear to me how it just doesn't seem relevant to it, but the time frame
Okay.
is what it is.
Okay. I was looking at the noise document. I need to find it. There are several here that you had submitted, and I was curious if you could please walk through the assessment and explain that a little bit more to me. Do you need to see it? Do I need to make sure I have it uploaded?
Yes, could you please present it?
Sure.
Can you identify the exhibit number for the record?
Oh my goodness. It looks like it was PET-GM-8. Now I've got to go back and find the doc. Bear with me. Okay. Can you see it? Is it legible?
Yes, thank you.
All right. Can you please
Uh,
walk me through this to explain what this report really indicates in translation to layman's terms here?
Sure. I'll do my best. So the equipment column in the table indicates the type of equipment that is that produces noise from the project. In this case, it's a 500 kilowatt project. And so there are 5 100 kVA inverters. That's why you see 5 of them listed here.
And that's the row? Is that the row in the field?
There are 7 rows total, so the number of inverters doesn't necessarily match the number of rows.
Okay.
It's a little bit separate from the number of rows. The other piece of equipment that produces noise is the transformer, and that's a 500 kVA transformer. And so our engineer took, if you scroll down a little bit, Carol, there's footnotes there. So there's equipment data sheets that the manufacturers provide that indicate the noise level of these pieces of equipment. And so we know the noise level. So if you look at the back at the table, we know the noise level at 3.3 feet. That's 65 dBA for all of the inverters and 56 dBA for the transformer. We also know the noise level at 200 feet and the noise level at 600 feet. Then we can calculate based on the distance to the nearest residence, your home, which is, each of those inverters are placed at different locations within the array. So that's why you see the different distances of each of the inverters to the closest home, as well as the transformer. We can then calculate the noise level of each of those pieces of equipment at those distances. Right? So if you take, for example, the inverters, you can see that the closest inverter to the home, inverter number 1, has a noise level of 27 dBA at that distance, 195 feet to the home, or apologies, 262 feet to the home. And as each of those inverters get further away, that noise level goes down. Same thing with the transformer. It has its own noise level at the distance it is from the nearest residence, 262 feet from the home. That is then summed in that combined impact dBA. That's 31.2. It's because noise is logarithmic. It's not a linear summation of those values. There's a logarithmic equation, and that's the relevant equations to the right of that graphic there. That's the logarithmic equation that's used to sum those total noise levels.
Okay. And then, so they're supposed to take this number here and translate it down to this range of what it equates to. Is that correct?
Correct. So if you look at the combined impact of all of those equipment, and this is 31.2 dBA, and that doesn't account for attenuation based on other factors such as topography or structures or other noises in the environment. But if you're strictly taking that noise level, you can compare it to other noises that we're all familiar with. So similar to the noise level of leaves rustling or whisper.
But it's 31.2, which falls under the range of 30 to 50, not 30. It is above 30, correct?
It is above 30, correct. 31.2 is the projected dBA.
So the translation to that is the I'm sorry?
Sorry.
Do you need bigger?
Yeah, a little bit bigger, please.
There we go. Does that help?
Yeah, so it's somewhere between the leaves rustling whisper to an average room noise level.
Mm-hmm. Can you please help me understand what is considered average room noise? In my household, the TV is going, the radio is going, the coffee pot is going, right? It's all relative. Can you please explain to me what is interpreted here in this document as average room noise?
And so, of course, as it shows, it's a range. It's going to depend on, you know, your household versus another household, but it's just to give a general idea of the noise level of that decibel value.
Like what?
I'm not sure I understand the question.
I'm trying to understand who makes that call. How is that? What is the determination of average room noise for the point that I called out? In my household, I have all of these different things that I hear in my house. Who and how, what report or how does it, who determines what is equal to average room noise? It feels like that is a subjective type of a description that could
So,
be
so
interpreted in different ways.
yeah, so this chart, as it says, comes from the Hearing Health Foundation. It is to give relative, you know, indication of different noise levels. Now, what is clear is that the combined impact is 31.2 dBA based on those calculations. So the table is designed to provide some context as to what that noise level is you know, relative to. But that noise level is the calculation determined based on the factors that we went through with the table.
So I'm seeing the two color delineations here, the green and the orange. One is in the safe range, one is in the harmful range. Yet this safe range does not necessarily mean an 87-year-old woman sitting on her front porch would not hear anything, correct? At
I
200
can't,
feet.
I mean, I don't know if I can speak to that. What I can say is that the the combined impact of the equipment at the distances that they are from the home will be 31.2 dBA.
Which is an average room noise. Okay. There's a difference, I think, of average room in a house and average room outside. Why would someone want to be outside hearing average room noise?
I think when you consider, right, like, for example, on this chart as well, in terms of another example would be the landscaping equipment from inside a house is 75 dBA. Right, so there are other background noises that are common in our environment that have significantly higher noise levels
Yep.
in their everyday. I mean, you know, being on a state highway, there's vehicles that are driving by.
Right.
So there's other background noises as well that aren't.
Can you talk to me about the noise and the frequency of the noise when you have these things connected up and it's running? The transformer is up and running. Is it like my air conditioner? When it reaches a certain temperature, the air conditioner stops and that noise stops? Or is it a constant noise?
It is something that's going to. It's not necessarily constant. That noise level itself is not necessarily constant. It's going to depend on the amount of sunlight. So those pieces of equipment are working based on the sun shining. And so when you know, at nighttime, there's not noise being produced. When there's different levels of light, there's going to be varying degrees of sound coming from it. But this would be the maximum impact.
Would you assume that that kind of a sound in a country setting is acceptable or is natural to a country rural setting?
Again, I think there are everyday background noises that are in a country setting or otherwise that you know, from farm equipment to cars traveling to wind. There's all kinds of background noises in a country setting or otherwise.
But the examples you share are part of the natural environment. The wind is the wind. Person needs to mow their lawn. How does that compare to a commercial installation in a rural environment being fitting into that natural setting?
I think I'm not sure that I would characterize a lawnmower or a vehicle as natural environment. It's something that, that's in our everyday environment. And yeah, I'm not sure.
Okay, so
I'm not sure I would characterize it the
I
same way.
okay, so how about characterizing it to a residential neighborhood? Those are natural sounds of mowing a lawn. How does this kind of sound on a 24 basis? How does that relate in terms of equivalency of a natural setting?
I'm going to object only because the premise of the question was that it was 24, and I assume that she means 24 hours, and Mr. Martin did not testify that the sound emissions are 24 hours. What he said was that
Okay.
they fluctuate during the day when,
Okay.
and that there is none at night. So I'd ask you to please rephrase the
Sure.
question.
Very fair. So in the daylight hours, when a lawnmower naturally is happening to mow the lawn, that's a natural noise that you would hear. And even commutes, right? Driving, more likely to happen during the day. That tends to be more of a natural activity as opposed to this commercial project installation that is not setting into this area. Can you speak to that how and why that noise would be acceptable, would be appropriate in this type of setting?
So as I stated before, the combined impact of 31.2 dBA, that is without accounting for sound attenuation from other noises. So when you have, like you said, when you have a lawnmower running or when you have vehicles passing by, those are sounds that are going to mask any other sound, right? And so that, again, I think it's important to remember on this scale where that 31.2 dBA falls. It's on, essentially between the leaves rustling and a whisper and an average room noise. And you compare that relative to other sounds that are produced during the day, which are much, much louder sounds.
But actually, I think I want to correct that. It is not between the leaves rustling and the average room. 31.2 is more than 30. So it squarely does sit into the average room noise, does it not?
And there's clearly it's on the bottom range of that range.
But it's still in the range of average room noise. So it's more than rustling of leaves.
So this, can we move on? This has been asked and answered. This has been asked and answered. If there's a different question, I think.
I'll sustain that specific objection to that question. Ms. Bushman, you can go ahead and continue your line of questioning, but please move to a different portion of this examination of this exhibit if you can.
Sure. Is it safe to assume with this combined impact, I'm trying to understand that explanation you gave earlier. I'm interpreting if you have one cricket, it's this sort of sound. If you have 3 crickets, it gets a little bit louder. If you have 25 crickets, it's even louder. How does that combined impact of how is that you're saying there's a formulaic approach to get to that number, but I'm trying to understand the logic of what I just described to this. So if you have sound from one thing versus many, it's got to accumulate at some point to be a louder noise. Am I interpreting that correctly?
Yes.
Okay. All right. Let's see if I can, are you still looking at the document? Because I don't
Yes.
see, okay, because I can't see my unshare. Stop sharing. Okay. Thank you. I want to bring into this part of my questions really an understanding of it was filed in the testimony and the notations that you wanted to meet with me. We wanted to halt this process until you've had the opportunity to meet with me. Go ahead, Leslie. You're coming off.
Well, if you can point to a place in his testimony where he said that,
It was in your notes that you submitted that this was part of the process, that there was a request that was happening and you were requesting specifically to hold off until the agreed upon arrangement that I had submitted to meet with Jeff. And I
So it's
want to
not
talk about the,
it's not in his testimony then, correct?
I guess here I am pro se trying to split hairs here. There is testimony, there's another document that specifically calls out petitioner said this, petitioner said that, petitioner has agreed to meet with Carol Boschman and Fernand Paquette, and that's what the document that I am referring to. So if that is not acceptable to discuss,
And I'm sorry,
did we
I just wanna
have a
be clear,
meeting?
is that document you're referring to, has it been admitted into evidence?
It's filed into the epoch. Whether it's considered evidence, that may be my pro se error.
Where was
It-
filed?
It's not, it's a letter. It's part of the record. It's not part of the evidentiary record, and she didn't file it as a cross exhibit. If, Carol, if you want to rephrase the question to ask him about something, but as we talked before, when we were preparing for the hearing, anything that you
Yep.
wanted, any document you wanted to cross-examine him on had to be filed as a cross-exhibit in advance.
Okay. So what I would like to do, Jeff, is engage and talk about the 2 meetings that we had in this process. And I'm waiting for you to go ahead.
I will object. Those were settlement discussions, and the substance of settlement discussions are not admissible as evidence in an evidentiary proceeding.
I
Your
guess I would,
response?
yes, I guess I would reply to that I did not enter that as a conversation for settlement. I entered that because I felt acquiesced to have that meeting because it was submitted by, I guess, Leslie, to that I had agreed, and the request was there to not proceed anywhere else without having had that meeting happen. And so I felt in a position that I didn't have any choice but to meet with Jeff. And so my intentions were not coming into a conversation as a settlement conversation.
What was the subject of the discussion? Just very
Settlement.
broadly, without getting into specifics.
The subject of
Go ahead, Carol.
you weren't there. I'd like to share what I understand as the conversation, Leslie, and then you can certainly add in. The topics that were the topic of the discussion was, Carol, what can we do to make it easier for your mother? What are the questions that you have to address? And I'd like to really talk through that conversation as to the aspects that were discussed in that in relation to the proposed project in its current state and what was being proposed as another alternative.
Give me a minute to think about this.
The meeting was to help resolve the adjoining landowners' objections and concerns, and from our perspective, they were settlement discussions.
And
And
I
just
walked
wanna-
into
I
that
just wanna
room
confirm and
not
be
having
clear.
intentions to come up with
I
an
just want to be
agreement.
clear for the sake of the record, there's been no agreement that's been filed as part of this record between the developer and the abutting landowners. Correct? So I'm going to sustain the objection that goes into settlement discussion or outside the evidentiary one.
Okay. At this moment, I think those are the questions that I had for Jeff, and I have a technical question, like as we progress through this hearing, if additional questions come back in my, based on the progress of this meeting, am I permitted to come back to ask the witnesses questions?
So what will happen is I'll ask the department if they have any questions of Mr. Martin, then I'll ask questions of Mr. Martin, then Ms. Cadwell will then have an opportunity to ask follow-up questions based on those questions. And based on Ms. Cadwell's questions to Mr. Martin, you can have another chance to ask follow-up questions with respect to what Ms. Cadwell asks Mr. Martin.
But not later on after
No,
other
this
witnesses.
is your one shot.
Okay.
So you go ahead and check your notes if you want to, and if you have any additional questions, feel free to ask them now. Happy to wait a minute or two while you check your
Thank
notes.
you. Gonna find my documents here. Can you talk to me about how you go through the process of finding the authors for these aesthetics reports?
I'm going to object. I don't know what that has to do with Mr. Martin's testimony or the merits of the case.
I'm sorry, can you repeat the question again? I apologize.
My question was the process that's involved in securing authors for the aesthetics reports. And the reason I'm asking that question is it has a direct connection to the author. And I don't know the answer. I'd like to know more about the industry.
I'll allow the answer if Mr. Martin can.
I'm sorry, Mr. Kosicki, I couldn't understand you.
Me or Mr.
No,
Kosicki?
Mr. Kosicki, I couldn't understand what you said.
I said I'll allow the question if Mr. Martin is able to answer it.
Ms. Daskus has decades of experience in this industry, and she is a highly qualified aesthetic witness.
So my question was, what is the process of finding and securing someone to write these reports? Is the industry really limited in it? Must it be someone from the state of Vermont, for example? And there are so many limited individuals that have the qualifications to be able to craft this type of a report?
Again, I'm going to object. I don't know what this is relevant to with respect to what Mr. Martin has testified. I appreciate that Ms. Boschman may have curiosity, but that's not why we're here.
I'm asking because this organization secured a contract, it appears, with Martha Statskas to write this report. And I'm ultimately curious as to how that individual might have, the objectiveness of that individual's writing of that report.
I'll overrule the objection. I'll allow the question.
Again, we as an organization, we have significant experience working with Ms. Daskus, and she is highly qualified, and has written countless aesthetic reports on other projects. So we felt that she was extremely qualified for this role.
Thank you. So the question that I was asking, Jeff, was about the industry and the volume of qualified candidates to be able to write this type of report. Is it extremely limited in Vermont?
I don't know if I would characterize it as extremely limited.
Okay. So how did you land to select Martha? I guess, was it through the organization? You just went to the organization? Vera? Is that your common organization that you partner with in getting these aesthetics reports?
Yeah, again, we've had lots of experience with Ms. Daskus as an organization, and again, based on her qualifications, we felt that she was highly qualified to be the aesthetics witness in this case.
Mm-hmm. So were there other qualified candidates that would have fulfilled this in an objective manner as well, and you chose to work with Martha?
We have worked with other qualified candidates in the past.
Okay. So when you had the letters received from the town and the NIVDA, did you see any was there an alignment in those two letters? And I'm going to try to find them so that you can. So we had a letter that was submitted from the town saying that they support based on the zoning, correct?
Do you be more specific,
The
Carol,
your
about what
preferred-
you're talking about?
I'm trying to get there. Bear with me. I'm trying to be taking my time, as you say, but moving along. Let me see. I had pulled up a bunch of documents, but that one was not. Bear with me as I go to that PUC site. There were some preferred site letters that were submitted, one from the town and one from the NVDA, right? Bear with me. What I'm trying to call out here, this is the joint letter that you received, correct? See if I
All right,
can-
what's the exhibit number you're referring to?
Oh my goodness. Oh, it's at the top here. No, it's not. The exhibit PET-GM-5.
Specimen, could you scroll up, please, on this document? Thank you.
Oh, that's what I was looking for. I didn't scroll up high enough.
Just
Sorry.
just wanted to make sure it was the exhibit.
For
That was,
the number. I took the hard road to find the number for you. This is the preferred designation letter you received from the town.
yes.
All right. And this is the preferred letter from, or the supporting letter from NVDA. Is that accurate as well?
It's the preferred siting designation letter from NVDA.
Yeah. Is it, I mean, they're talking about known constraints and non-constraints in this specific paragraph here, right? And they call out those descriptors, but they also call out, based upon their joint letter, Canaan Select Board and Planning have made determination considers the location to be preferred site. Is that giving you any specificity around NVDA's rules, or do you see that as a deferment to the Canaan boards?
I'm going to object only insofar as the letter speaks for itself.
I'm just looking for confirmation. I don't see these letters on a regular basis. There's another exhibit I submitted that has quite a lot more detail. And I can call that number up right now if you want it. But right now, I'm just trying to understand there isn't any specific guideline that they call out from their regional planning documents in NVDA that this site supports their guidelines. Is that what you interpret in here as well, Jeff?
Hold on, there's an objection. I'll allow the question. I do think we're getting a little far afield in terms of the scope of this question, but I'll allow it.
Yeah, I would defer questions specifically to the NVDA plan or the town plan to Ms. Daskus as they relate to orderly development. I'll just state generally that the paragraph that you called out, looks like the third paragraph in the letter, NVDA staff has reviewed the proposed project location. That's referring to their review of the project location. And then they include a paragraph below that refers to the town's review of that same location.
Okay. So is it safe to assume that they're deferring from this paragraph based on their joint letter? It appears that both Canaan and Select Board have made determination to be a preferred site.
I wouldn't want to speak for NVDA and make
Okay.
that.
Okay. I get it. I apologize. I had my own work team shut off, but it appears it's still there, and I don't know how to shut that off without getting kicked out of this hearing. So I will do my best to make sure that that doesn't happen. On a break, maybe I can look for another setting that can turn them off, but we're in the throes right now. Okay. Thank you for that. Can you talk about the location in the field itself and the assessment that brought you to choose that particular location in the field?
Sure. So that, we looked at multiple options. And we settled on the location that is before the PC now, based on several factors. But maybe one of the most significant of those factors is the landowner and their desires, particularly specifically their desire to continue to farm the property. As you're aware, the property has been in agricultural production for many years, and their goal is to continue to be able to maximize the agricultural opportunity of the property. And so, in consultation with the landowner and in their consultation with the farmer, that was the best location, the location that met that goal or met that need, because A, took up the least space on the property, so had the smallest footprint of the options that we looked at, and also not just about the physical footprint, but based on the geometry of the design, it limited the sort of like cutting up of the property or stranding portions of the property that maybe wouldn't be that wouldn't have solar physically on them, but that because of the amount of space available would not be accessible or would not be feasible to continue to farm at those locations. So landowner and farmer input was a significant reason for the location. And then the other piece would be addressing the regulated criteria under Rule 5.100. So in particular, this design has the smallest impact on prime agricultural soils, which is one of the regulated criteria because of the smaller footprint and also because of the shorter access. It also avoids the natural resources on the site, including the wetland to the east and the associated wetland buffer, as well as the rare plants to the north. And then there's also an aesthetic component to it as well that, again, I would defer to Martha on that piece, but that was another factor in the decision.
Okay. I'm going to bring up, hopefully this is the most recent document for your site plan. exhibit PET-GM-2. Is that accurate? Is that the most, so that we're looking at the same thing? Welcome to the world, it's small. I want to make sure we're working off of the same one.
Carol, is the document number, the one that you pulled up, is the document number 798383? The one that was filed, so there was the revised page 1 that was filed in February in response to comments from the Agency of Ag, and I just want to, I guess you can probably tell if the
Well,
it's
I don't know.
ag soils are
That's not
inside.
it. That's not the one?
Yeah, that's not the revised one. There was one where the prime ag soils are within the
Okay.
fence.
All right, I wanna make sure I'm pulling the right one, so
Yeah.
bear with.
I think if you scroll down, oops, I was gonna say, if you scroll down, you can see whether the prime ag are inside the fence. That was the
Oh,
difference.
do you
Yeah.
yeah, I apologize. Let me see if I can find a
No
revised
worries.
site plan here. Again, several documents and I see nothing when all you see is tabs and numbers. You don't know which ones are the ones. So I thought it would be easier to 6 photos. Revised site plan, February 22nd. February 17th.
17th. But that first page.
I thought that's.
That might have been. I think if you scroll down, we could have seen whether the prime ag soils were.
I'm gonna.
There I am.
Yep.
Talking with my hands again.
That you zoom in, that one looks like the right one.
Okay, so we're working off of the accurate one, which is, I think, the one I had. PET-GM-2. Oh, revised. There we go. Okay. So I'm really, the visual that I am trying to understand here. So you're going to have trees right in front of our property. The transformer road or the road itself is moved over to be away from directly in front of the driveway, correct?
Correct.
And you were adding a couple more trees around what I'm assuming is where the transformer, to try to hide the transformer. Do I have it right?
If these are questions related to the aesthetics of the project, I would defer to Ms. Daskis. But
I'm
this
just
review,
asking about the plan that I'm looking at that your company would have crafted.
sure. I mean, this plan that was submitted with the application is, I think you're pointing out some of the changes that were made in response to the comments that we received in part from you during the 45-day notice process.
Okay, and this area that's got the diagonal grids is where the staging area for the equipment would be, and then ultimately that would be returned back to be agricultural cropland, correct?
That will be reseeded and mulched at the end of the installation period. That's a temporary staging area.
So does the temporary staging area for the 20-year period become non-farmable land?
Nope, it could continue to be farmed.
Is that the intended plan? Or is it
I
just to be seeded to be grass?
haven't spoken with the landowner specifically about the plan for the temporary staging area.
Okay, so if it were not to be crop land, now what are we talking about for disturbed? We're back up to the 4 acres as opposed to 1.9, correct?
The site plan shows the limit of disturbance and the footprint of the array, which is the area within the fenced area, is 1.9 acres.
Right, but it's about 4 acres to include the temporary site for the equipment, correct?
The 4 acres includes the entire limit of disturbance, which does
Includes
include
the
the temporary
staging area?
staging area.
Okay, so it is unknown at this time if that will return that agricultural soil for the staging area would return back, kind of be thrown back into the crop opportunity. That's unknown as to what will happen at that point. Right now, you can only comment to the staging area.
Yeah, the landowner has expressed an interest in maximizing the agricultural use of the remaining property area, and that temporary staging area is not part of the solar array area. So this is an assumption that would return to agricultural production, but they
Okay.
haven't had a specific conversation related to the staging area itself, whether that would be returned to agricultural production. It would be available for agricultural production.
So it's safe to assume, correct me if I'm wrong, right, that part of the area is unknown and possibly would not be used for crop back to the agricultural soil space. So we are still talking about the prospect of 4 acres not being, as opposed to the 2 acres that have the actual solar panels. Is that right?
Again, all I can say is I have not had a specific conversation with the landowner about the staging area, but that acreage is available for agricultural production, and we have spoken, several times about the desire of the landowners to continue to farm as much acreage as possible on the property.
Okay. How long a period of time will that staging area be off limits for crop?
The construction period of an array this size is generally between 3 to 4 months.
Okay, so there's a period of time where the materials have to get to the site. Then there's the period of time that the site is actually being built. And then there's a tear down of removing whatever leftover materials are not being used, right? Does that 3 to 4 months comprise of all of that?
Generally speaking, 3 to 4 months would comprise the entire construction period.
Okay. When we talked about this location in the town meeting and even in the private meeting, right? We were asking questions, we meaning all of us, the community that was present in that meeting, why you picked that location, why not consider something further back. I would like to have you say it again here. The reasoning behind that.
Yeah, absolutely. If we put it further back, I mean, one of the primary concerns, again, was the landowner. That's not an area of the property that the landowner considered for putting a solar array. It would limit the agricultural opportunity on the property. So that is a significant factor. The other significant factor is the length of an access that would be required to get to the back of the property there, and the impact that would have on the prime agricultural soils on the property, which are throughout the property. Okay. So the access would require excavation through, essentially, if we were located in the project in the eastern side of the property, that would require excavation through the entire length of the property to get back to that portion of the property. And all of that would be impact to prime ag soils.
Mm-hmm. But if we're talking about 4 acres approximately for the staging and the amount that is proposed to be solar arrays, whether it's in this corner here or the back corner, it's still the same amount of land that would be impacted for the solar arrays, correct?
No, that's not correct.
Okay.
The amount of land that is required for the footprint of the array depends on the geometry of the design. So as you have to space the rows far enough apart to prevent inter-row shading. And so if you have to design the array, if you look at that portion of the property, there's a wetland on either side to both the west and to the east.
Are you talking
And
the other area, the other corner here?
correct,
Okay.
right? So there are two wetlands, one to the west, one to the east, and they're associated 50-foot buffers. Would require a completely different design of the array that likely would require additional rows and additional spacing. So that would take up an additional, a larger footprint. And then maybe just as importantly, again, because you would be, the project would require an access to lead to the back of that property, it would make that entire portion of the property inaccessible to farming. And it would also impact the western side of the property as well, with that access and the line extension that would run along it.
But by moving it to this location, you're no longer 200 feet from the residence. And it's not just one, there are several here. Proximity to that location. Is that correct? And would, well, I'll let you answer that.
Yes, and again, it's a discussion that has to incorporate the landowner's requirements as well as the requirements of the Rule 5.100, and ensuring that we're addressing all of the regulated criteria.
And at the end of the day, moving it really is, even if you're reconfiguring, it's just adding an extra cost to the company. Is that correct?
There would be additional costs associated with a longer access and a longer line extension.
So it would seem to me that if we're talking about aesthetics and blending into the community, locating it in a different area, not along Route 102, not in front of residences, and having even more natural shielding, screening of said property, said project, if it was moved in a different location. Would that not be the case?
So I'll let Martha speak to any questions related to aesthetics. Again, I just want to emphasize that this design was done in direct consultation with the landowner and the farmer, as well as considering all of the relevant 5.100 criteria.
So beyond the farmer, who isn't the farmer, they lease the land, right? As long as they're able to quote, as they were quoted in a local newspaper, harvest the sun, they're going to get more money regardless than they would for leasing out the farming area. So their goal is to make more money. You're in conflict with this proposed question or idea of why isn't it considered in another location because of the cost to make that thing happen.
I'm going to object. This is just argumentative. I think she can pose a question.
I sustain that objection. Ms. Boschman, if you have a question for Mr. Martin, please ask the question.
So does the equation of making the site suitable and the location on the site, how much impact does the cost of the project from the solar company's perspective come into that consideration?
In this case, the landowner was very clear about where they did not want the project. That was very clear that location was not an area of the property that they were open to leasing for the project.
Did they give a reason why?
As I stated earlier, the reason being that they want to continue to farm the rest of the property, and that location restricts significantly the ability to farm the rest of the property.
As opposed to all of this area now that is suitable for land crops?
Again, this has been asked and answered several times.
Okay.
So I object to continuing to badger the witness with the same question asked a different way.
I'll sustain the objection. I don't.
Wow, pro se is badgering. I'm so sorry.
Yeah, I don't necessarily agree with the characterization that it's badgering, but I will sustain the objection.
Thank you. So when you had your team of engineers craft this plan, there is only screenage accounted for here, correct? For trees, natural screenage that will be planted in this area, correct? Alongside Route 102. The green dots represent
the-
trees,
Those are plantings.
screenage, plantings, trees.
Yep.
Okay. And there is none of that accounted for here along the full length of the array here, correct? Nor during the staging area, any of that area. There is no accountability of screenage whatsoever.
So again, the questions related to aesthetics, I would defer to Marcus Gaskis.
I'm asking about what I'm looking at on the plan that was
There's
developed
no-
by your organization.
There are no plantings proposed in that location, but in terms of screening, I would defer to Marcus Gaskis.
Okay. But you hired Martha to write the aesthetics report. So I'm asking you why there are no trees. This was your proposed plan from the company. Why is there no screenage here at all?
Right, we hired Martha as the aesthetics expert, and in her determination, as she's laid out in her report, the plan that has been proposed meets the review criteria in terms of aesthetics.
Thank you for your patience. I'm taking advantage of take my time, but get to the point. So at one point in a conversation that you and I had, I asked the question, why did you do it in this location in front of this area? And you came back with a different location from your engineering team, correct?
Again, the discussions that were had were for the purposes of settlement, and whether you considered it settlement or not, they were for settlement. And the only plan that's at issue here is this plan.
Okay.
And so I would object to getting into the discussions and alternatives that were a part of the settlement discussion that were rejected.
Unless Ms. Boschman, unless you can point me to somewhere in the testimony or the record, otherwise in the record that speaks to this alternative location, I'll sustain the objection.
Okay, great. When you work with these organizations and you have the statement of interest from both companies, right, that have expressed interest, where and how does that process come along in respect to the site location and the surrounding community's impact or availability to or access to that?
Sure, I understand the question. Could you please restate it or rephrase it?
Sure. You have two letters that were submitted of letters of interest outside of the Canaan Township, expressing interest to receive the benefits of this project. Why is Canaan not part of that recipient of the benefits of this project?
We would generally be happy to work with the town, with the school district. I mean, that is historically what our company has done on many projects throughout the state. We work with towns, we work with communities, schools, local businesses, and nonprofits. Under Act 179 of 2024, that legislation included a requirement that credits to offsite customers would only be allowed if the system serves a multifamily building containing rental units serving low-income tenants. So that is a statutory requirement. And so, we've, as Ms. Caldwell mentioned earlier, we've done lots of outreach to different entities that would meet that requirement. And there's actually one entity in Canaan that does meet that requirement. And we reached out to them and we never heard anything. So these are the Rural Edge is their letter of support is what we've submitted based on the communications that we've had with them over the last several months and based on their eligibility under that Act 179 requirement.
Okay, so non-legal, does this statute or law or whatever you stated, 179, right? Does that disqualify the abutters that are being impacted to some site build?
Good question. My understanding, based on the statute, is that either the system has to serve multifamily buildings that contain qualified rental units serving low-income tenants, or 100% of the credits have to be used on the same or adjacent parcels. And I would expect, given the size of the project, that the adjacent parcels would not be able to use 100% of the output from the survey. And that's my understanding of the statute.
Okay, so I'm in a position right now that I don't know the law that you're describing. And you're stating that's your impression. So it is what it is. That is the answer to your question. I get it. I'm trying to understand from you how, at a minimum, if this is coming for harvesting the sun and making a profit, how the surrounding communities in here, it's an equity issue to me, and how to balance the site location so that there's equity for all if this were to be moving forward. I don't necessarily see that here, and I'm wondering how you can react to that.
So I would say we would be willing to work with the adjoining landowners. We would be willing to provide net metering agreement from this project. But again, my understanding of the statute is that 100% of the credits have to be used on site or adjacent parcels, or the credits have to go to multifamily buildings containing low-income tenants. So that is a statutory requirement that the project has to address. And I would just add that the project is or will be serving low-income offtake, and so there is a equity component to the benefit of this project as well.
And what is deemed low income? Because my mother is retired, not employed, no income. The next door neighbors are retired, unemployed, no income. So how does that disqualify? What is the qualifier for low income? And well, we'll go there.
So again, we're meeting the requirement that's laid out in statute, and in order to do that, the project needs to serve properties that contain qualified rental units and that have what's called an Act 68 certification.
Is that the only mechanism for you to be able to put this site on property, this particular statute, because of the size, or is that the one you decided to align with as a company?
Again, my understanding based on statute is that either the project has to serve properties that have these active 68 certifications, or it has to serve, 100% of the output has to go to either on-site or adjacent parcels.
So what I'm trying to understand, is it because of the size of this particular project that automatically aligns to that statute, or are there several statutes or not that you can choose to align with?
Its ability to participate in the net metering program is what where that requirement comes from. So it's not necessarily based on size, but the net metering program is capped at 500 kilowatts. So there is a size component, but it's really the participation in the specific net metering program that comes with that requirement.
So was that the only option to be able to proceed with this proposal, was the alignment to that one, or not?
I want to make sure I understand the question.
So I'm hearing very clearly there's a specific statute that has specific rules and regulations of multi-unit housing, low-income housing. And I'm trying to understand if that's an intentional alignment that discounts us as abutters or the community if this project were to move forward, right? Because where I'm coming from is the landowner looks to gain a profit. The company looks to gain a profit. The abutters are going to have a negative impact to their natural environment and don't have anything out of this scenario. And I'm trying to understand the equity of that equation of what I'm describing here.
Is there a question?
I'm asking again, if that was the only way, the only option towards submitting this plan to be able to move forward and get support from the PUC to move it forward. Because if it
So I'm going to
does,
object. Again, I'm going to object, sorry, because you've asked that question and he's answered it several times.
I'm still a little unclear about what the question is. If you want to try to rephrase, Ms. Bushman, please do.
at the end of the day, we are contesting to not have this thing at all. But I have a real understanding that a decision needs to be made, and one of the options of one of those avenues will be that it would happen. And I'm trying to understand, if it were to happen, how the equity of the landowner getting profit, gaining something, the company gaining profit, gaining something at the cost of the property abutters, that at minimum.
I understand the concern that you're trying to address, but there needs to be a question to the witness that speaks to that concern.
Okay.
And
Is there?
I'm just saying, what I'm hearing from you is you're laying out the concern that you want to address, but I'm not hearing a question to the witness.
Sure, I can
that
ask
speaks
it.
to that concern.
Is there an avenue, should this project go forward? Is there any avenue or possibility where the abutters, the residences who have electric bills and have those kinds of scenarios, have bills that they pay, that they may be able to leverage beyond the 120, whatever that act that you have?
Again, he's answered this question more than once. And the answer was that the abutting properties have to take 100% of the credits. So that's on the record several times.
I'll let him, I'll overrule this objection. I'll let him answer that question.
I'm sorry, Mr. Kasicki, I'm having a hard time hearing you. Could you state that again?
Sorry, I'm going to overrule the objection, and you can answer the question that was just posed.
Okay. Yes, as I've stated, the project would be willing to work with the abutting property owners and provide a net metering agreement with abutting property owners. However, it is our understanding that statute prevents us from doing that. So again, our understanding of the statute is that 100% of the output would have to go to abutters or the parcel on which the project cited.
In other projects similar to this, have you engaged in that kind of a process and had success in affording the abutters those opportunities?
I'm going to object insofar as this case is about this project, and whether in the past, before the statute changed, they could do it really is irrelevant to the equity question that Ms. Boschman is trying to explore here.
Do you have a response, Ms. Boschman?
I think it has a lot to do with the equity aspect of, having the disruption if this project were to move forward and having no benefit to it whatsoever, no compromise whatsoever to having this thing in our face every day for 20 years. And the landowner, as you can see in this parcel, doesn't even live here. So the landowner doesn't really care about where and how and what's happening with this.
I understand. I'll overrule the objection. I'll allow the question, but I think to Ms. Cadwell's point, this line of questioning is becoming repetitive.
Okay.
So I'll
I
allow you to
understand.
ask this question, but let's try to move along in the line of questioning.
Could you repeat the question?
I believe the question was, have you in other projects ever engaged in that kind of arrangement where this size of, even regardless of size, where a project engaged in the compliance of that rule, but also afforded the abutters the opportunities for the credits as well?
Prior to the passage of Act 179, this requirement was not in place, and Norwich Technologies has many community solar projects throughout the state of Vermont where residents can participate directly in the projects.
So are you saying, yes, you have engaged in that where both would be happening, the low-income housing and the abutters receiving the credits? Is that, I think that's what you're saying, but I want to get confirmation.
I can't confirm that there's been a project where there's been both low-income multifamily units and abutters. Not in my experience.
But it's part of conversations. Okay.
Again, we have developed and installed many community solar projects in our company's history.
Okay. All right. I'm back. Did you all lose me? No, I lost you. Sorry. I had the whole, the circle. Okay. I think at this point, I've asked enough questions of you, Jeff. Thank you for your patience.
Thank you.
Thank you, Ms. Boschman. Does the department have any questions for Mr. Martin?
I have no questions for Mr. Martin. Thank you.
Thank you. I do have a couple of follow-up questions. A lot of the issues that I was interested in, Ms. Boschman covered in detail, so this will be fairly short. Just want to turn your attention to pages 7 to 8 in your testimony. This is your initial testimony. This is the section that speaks to the responses to the 45-day comments that you received. And in there, you respond to a number of comments from abutting landowners and also from the Agency of Agriculture and Agency of Transportation. This is just to kind of clean up the record more than anything else, but are you aware that the Agency of Natural Resources also filed comments in February 4th of 2026? Does that ring a bell?
Yes, these are the comments related to the prime agricultural soil storage stockpile area.
No, that was the Agency of Agriculture. I'm talking about the Agency of Natural Resources.
Oh, I apologize.
Yeah, I'm just, well, the reason my question is this is that you speak to comments that you received from other agencies, but there was also some comments that were received from ANR and they're not responded to in your testimony, at least I didn't see it in there. So I just wanted to confirm that my question is this, is that in the agency's comments, they proposed 2 CPG conditions. Are you aware of that? Does that ring a
Yes.
bell? Okay, and I just want to confirm, are you amenable to having those conditions as they were presented in those comments? One, related to having a wetland delineation performed, and 2, having flagging around RTE plant species. You're amenable to those conditions that are proposed by ANR?
Correct.
Okay, thank you. That's all I needed.
Apologies. I thought you were.
No, it's fine. I'm just, I assumed that that's the case. It wasn't a huge deal. I just wanted to make sure for consistency's sake, that was all in there.
Yep.
The other question, I just have another follow-up question with respect to the discussion that you had with Ms. Boschman about the sort of the site selection for the facility on the parcel of land. And specifically the discussion you were having with her about reasons why the facility wasn't proposed to be placed on the eastern side of the wetland and forested area. Are you understanding where I'm talking about without pulling up the
Yes.
map? So I know that you spoke to, if my recollection is correct, it's the landowner had concerns about ensuring maximum farmability of the land going forward. The idea that there might be a bigger footprint if it were to be sited over in that area in a longer road. Beyond those issues that you spoke to, are there any other sort of impediments to the operation of a facility if it were to be placed in that area as opposed to where it's being currently sited that you identified with looking at the site?
Are there other impediments to the facility for being sited in that area? Was that the question?
Yeah. Did you identify when looking at the site, and it sounds, I'll ask this question first. Is it correct to say that you and the landowner did look at potentially siting the facility at the eastern side of that wetland complex that's sort of in the middle of the parcel?
We looked at it and it was a no.
I'm sorry, what was that at the end?
I said we looked at it and it was a no from the landowner.
Right, and I know that you articulated the reasons you did earlier about why that was a no. I'm asking, aside from those reasons, would there be a problem to operate? Would there be any problems that you could identify to operate the facility in that location versus where it is currently being proposed? As you sit here today, I understand that this is probably
right. Yeah, as I sit here today, I think my concern would be about just the layout and the 2 wetlands on either side of the area in that location of the property. But again, the primary issues are the ones that I raised earlier.
Thank you. That's all I have. I appreciate it. Ms. Cadwell, do you have any redirect?
I do. I have a couple questions, a few questions, I think. So, Mr. Martin, you recall some questions from Ms. Boschman, and now I guess from the hearing officer about considerations to siting the array and the location that it is. You recall that?
Yes.
How did the statutory setbacks play a role in siting the array? And can you explain what those are?
So the statutory setbacks that were considered, of course, were setbacks to property lines, as well as to public traveled way on State Highway 102, as well as to the wetland to the east of the project. So the project was cited in a way that addressed that setback to the wetland to the east, but butted up against that wetland buffer as much as possible, and also addressed the property line and setback to the traveled way.
With respect to Ms. Boschman's inquiry about the location so close to the property that she and her mom and brother own, are there other projects that you're aware of that have setbacks similar to the 195 foot to Ms. Boschman's property, or property that she's the owner of?
Yes. Just a quick look at our projects. We've developed and installed at least 4 projects that have at least at a maximum of 195 feet from the nearest residence. So project West Fairleigh Kendall Solar Project is 165 feet to the nearest residence. Hartford Wilder Well is 134 feet to the nearest residence. Barry Beckley Hill Solar is 145 feet to the nearest residence, and Duxbury 100 Solar Project is 195 feet to the nearest residence.
And turning your attention to the questions regarding the use of the staging area and the amount of time for construction, can you tell me whether the project can be constructed after the growing season?
Yes, the project could be constructed after the growing season. It could be constructed in the winter. And so, obviously there's no planting that could occur during that time.
And
I'm sorry, what was the back end? I'm so sorry, I didn't hear the back end of that answer. Could you repeat that?
Oh, that the project can be constructed outside of the growing season. It could be constructed in the winter.
But I thought you said something. Okay, sorry.
So it's fair to say that the construction of the project can be done so as to not interfere with the growing of crops.
That's correct.
And turning your attention back to the questions about abutting landowners having the opportunity to get net metering credits, roughly, what's the estimate for how many homes a project like this of this size could serve?
We typically a project of this size could serve approximately 135 average households.
And are there 135 households that abut the property, the host property?
No.
Sorry, I interrupted you. Sorry, I interrupted you again.
No.
And just to be clear for the record, the staging area, when construction is done, the staging area could be used for the production of corn, correct?
That is correct. Staging area would not be part of an exclusive lease area, meaning it could be used for agricultural production.
I have nothing else.
Thank you. Ms. Boschman, you have an opportunity to ask follow-up questions, but only with respect to any of the redirect that Ms. Cadwell just had
Do
with
my
Mr.
best.
Martin. So,
I'll do my best to be in the guardrails.
right. Well, and so here's a good way to think about this, which is before you ask a question, ask yourself the question, can you identify what question Ms. Cadwell asked Mr. Martin, and then link your question to that issue? So.
So let's work backwards, short-term memory. In the staging area, she was just talking about whether or not crops can be added once the staging area has been completed. I want to reconfirm that that's not been identified by the landowner that is going to happen, correct?
I have not specifically talked about the staging area with the landowner. We have discussed the desire to farm as much of the available property as possible, and the staging area is available.
Okay. And you talked about, I'm sorry, Ms. Caldwell talked about numbers of households and the accessibility to this project and the electricity. You mentioned at least 100 households as an answer that this property could serve. Is that right? Did I hit it right?
Based on average electricity usage of a typical Vermont home, the estimate is that this project would produce enough electricity to serve around 135 households.
Okay. Can you connect that to the two letters that you have of letters of interest? And what I would like to know is those two organizations, do they have 135 or whatever that number is, households available to meet that need?
Yes, Rural Edge has many multifamily units and could fully subscribe to the project.
To the number of 100 and some odd households.
Correct. The amount of electricity that those multifamily rental units are consuming could, still going to phrase this, the project could, all of the output from the project could be applied to those accounts.
So it's not about number of households, it's about amount of energy then that's being consumed.
The households is really to give a sense of the scale of the project.
And does it, or what happens if there aren't enough households from those two letters? Where does the rest of the electricity go?
So now I'm going to object. This is going way beyond what I asked her about, what I asked him, which was specifically about abutters.
Yeah, I'll sustain that objection.
Can I rephrase?
Sure.
If there is a capacity reached and there's leftover electricity, voltage, whatever it is, for what is being created out of this project, how and where, is it possible that at that point, where does that electricity go? Where do those credits go?
I mean, a condition, excuse me, a condition of the proposed CPG is that the CPG holder will verify with the commission that the project will serve one or more multifamily buildings containing qualified rental units serving low-income tenants. So that is a requirement. So I don't, I can't speak to that particular situation, but the output from the project has to go to eligible accounts.
So if these two letters meet the requirements and there's leftover, does it just go to the, is it VEC for credit for?
Theoretically, in this hypothetical situation, those credits would be wasted. VEC is going to receive all of the actual electricity from the project.
And farm it
and
out
that-
to those said companies that, or housing units that you're talking about.
The net metering credits are separate from the actual electricity. So the electricity would go into the grid, no matter what. The credits are separate from the physical electricity, and those would be applied to eligible accounts.
Okay. And eligible accounts equals low-income housing in a multi-unit as opposed to individual residences.
The eligible accounts equals the statutory definition, which is the one or more multifamily buildings containing qualified rental units serving low-income tenants.
Okay. That's it.
Thank you. Mr. Swain, I assume you don't have any follow-up.
That's correct. Thank you.
Thank you, Mr. Martin. You're all done. You're released. Guess the next order of business, we've been here for a little over 2 hours, and we are creeping up against the lunch hour. So I just want to take the pulse of the group here to see how we want to schedule things. I think at the very least, we want to take a little bit of a break. But does the group want to take a bit of a longer break to get some lunch? And then we'll return with Ms. Staskis.
I will defer. I definitely need a nature break.
Sure.
Carol, I think, wants a break to stop the messages from popping up. Maybe also a co-nature break. And I guess I defer to my next witness, Martha, on, what is your preference in terms of doing a nature break and then coming on and then breaking for lunch, or breaking for lunch?
Well, I don't care about that. I do have a hard stop at 3:30. That's all I want to put on. I didn't know this. I can't go past. I have another commitment with my town responsibilities.
I would hope, irrespective of whether or not we take a lunch break, we would be done by 3:30. I hope.
Me too.
So
Hey, you asked
it's
what
re-
the estimate, and I told Leslie I had no idea what this was going to entail, so I
Right,
apologize.
I understand that. It's really up to the group.
Do you want to say 40 minutes? Do a
All right,
quick.
let's do this. Well, how about we reconvene at 12:30, lunch break and everything. All right, I'll see you all at 12:30.
Thank you.
And do we
Thank
stay
you.
on and just mute and shut our cameras off?
Yeah, I'm going to stop the recording, so it doesn't really matter what you do. And then when we get back at 12:30, I'll start recording again. So
Okay.
I would suggest just everybody turn their camera off. So,
Okay. Thank you.
Thank you.